Hi, I'm Greg Herman, the editor of Flu, and once a month, starting with this video, I'm going to be posting a short video highlighting one of the things that is in Flu this month that I think is of importance or interest to our readers. This month I'm going to start with a case whose name I can't pronounce, so I'll spell it for you. It's BJORGO, a Wisconsin Court of Appeals case. And it's a case that's of importance because it deals with the application of sub-S income for support. The case is not recommended for publication by the panel of the Court of Appeals which decided it, but as a signed opinion, it can be cited for its persuasive value. The Family Law Section of the State Bar of Wisconsin is going to be asking the Court of Appeals to publish the case, in which case it can be cited for precedential value, but one way or the other, either for persuasive or precedential value, it will be able to be cited. And it's important because we don't have a whole lot of case law on sub-S income, either in Wisconsin or for that matter nationwide. Sub-S income, simply put, is where a business owner elects to have all of the earnings of a business reported on his or her tax returns rather than having to file separate business tax returns and report the income on there. There are two reasons business owners do this. One, it avoids the risk of double taxation, in other words, paying taxes at both the corporate and individual level. And second, in general, individual tax levels are less than corporate tax levels. So a lot of business people elect sub-S treatment for perfectly valid reasons. It creates some complications in divorce, though, because it's fairly easy if you have a W-2 earner, whatever income is reported on the W-2 is income they earned and available for support, and that may or may not be the case with sub-S income. The company can issue a K-1 directing that owner what income to declare in his or her tax return without distributing sufficient cash to pay for the income declared on that K-1. And then the question becomes, well, in Wisconsin, we treat all taxable income as income available for support. But would that be fair in an individual case where the cash received may or may not be the same as the amount of income declared for taxes because it's corporate earning that wasn't distributed to the individual? It tends to be easier for child support because pretty much courts are going to figure whatever income's around, they want the maximum amount to support the child, but it may or may not be appropriate for maintenance. And the other issue that comes up deals with whether or not the owner has a majority interest and therefore can make the decision as to how much cash to distribute, or is a minority owner, in which case that decision's made by somebody else. If this case remains an unpublished case and only citable for its persuasive value, it's really not a huge deal, and it's perfectly fine for a court then to ignore the case since it's not precedential, it's merely persuasive. My preference would be that this remain a signed but not published opinion, because it appears from reading it that it may not have been fully addressed at the trial level in terms of the ramifications of the sub-S income. There's some indications in the opinion that the Court of Appeals isn't real thrilled with the record below. In any event, for those lawyers out there who handle cases involving sub-S income, either representing the business owner or the non-business owner, and the income available for support is important, this case needs to be read under any circumstance and carefully considering what the Court of Appeals says, which tends to be towards wanting more income available for support as opposed to less. I'll be writing a column on this for Fast Track which is my new column that will be is being published by the Wisconsin Bar Association. So please watch for that. And after it's published in Fast Track, I'll post the article on my office website.